Amending your governing documents. Your governing documents typically include CC&Rs, bylaws, articles of incorporation, architectural guidelines, and community rules. For the purposes of this discussion, we will focus only on the CC&Rs and the bylaws. The remaining documents can usually be amended by different processes than those discussed here. Why would you want to amend your governing documents? There are a number of reasons, including legal reasons, administrative reasons, and corrective measures. For instance, amendments might be needed to bring your community documents into compliance with new legislation. Recent examples of this would include amendments to adjust how your community deals with renters or who it files liens against, each of which have been the subject of recent legislative changes. Or, amendments might be desirable because it has become apparent that things just aren't working right under the current governing documents. For example, the community might want to make changes to how long board members serve or to stagger their terms in order to provide more continuity. Or certain regulations might be proving too restrictive or not restrictive enough. Finally, you might simply need to fix mistakes existing in the governing documents. These can range from simple mistakes like the wrong community name in a section of the documents to more substantive mistakes like errors in the property description, including in the CC&Rs. A simple mistake might have no real legal impact, but more substantive mistakes can result in serious problems. Once you've determined that amendments are needed, the next question is how to do it. Although the work involved with amendments can be quite complex, we'll boil the basic steps down to just 3. First, it's important to note that the process will vary based on whether the community is under the control of the developer or whether turnover has occurred. In both cases, the amendment process is governed by the documents themselves. But before turnover, the developer often reserves the right to amend unilaterally. After turnover, amendments should meet the following requirements. 1. They must be approved by a vote. Utah law specifies that amendments to bylaws and CC&Rs must be approved by at least 2/3 of the community. 2. Any requirements for mortgagee approval contained in the governing documents must be complied with. Often, the CC&Rs will contain provisions saying that certain kinds of amendments must be approved by both the community and by institutions holding mortgages in the community. For the most part, though, if an institution is notified of such changes and they do not object, their approval can be considered granted. 3. The amendment must be recorded in the recorder's office of the county in which the community is located. It will need to be recorded against each and every lot in the community. If yours is a large community, recording fees can get quite high. Because legislation is constantly being adjusted and a community's needs typically change over time, governing documents will usually need amended on a fairly regular basis. But this is a good opportunity to evaluate how your community is running and address all of your current needs. Good luck, and thank you for watching a video from Welker Benjamin PLLC, a community association law firm.